What's up, guys? Dom here with Restricted America. Um, Today, I'm going to be talking about a court case coming out of Maryland, and it's the 4th District of Appeals. So, I know I've been pumping out a lot of videos about Massachusetts and H4 885, but this one's going to be a little bit different. We're going to zoom out, and we're going to talk about this case a little bit, and we're going to read an article. We're going to talk about why that would be important for Massachusetts and really all states that have severe gun restrictions and assault weapon bans. So, without further ado, this is the title is U.S. Appeals Court Upholds Maryland's Assault Weapons Ban by Nate Raymond. This was written on August 6, 2024. And we have a federal appeals court on Tuesday rejected arguments by gun rights advocates that Maryland's ban on assault-style rifles such as AR-15s was unconstitutional, despite a 2022 ruling by the Supreme U.S. Court that expanded gun rights. The Richmond, Virginia-based 4th U.S. Circuit Court of Appeals, on a 10-5 vote, held that a decade-old assault weapons ban enacted in response to mass shootings and other gun violence does not violate the right to keep and bear arms under the U.S. Constitution's Second Amendment. That's funny. The ruling came in one of two major Second Amendment cases decided by the full 4th Circuit on Tuesday. In a separate opinion, the court, in a 13-2 vote, reversed a West Virginia federal judge's ruling that found a federal ban on possessing a gun with its serial number removed was unconstitutional. Gun rights groups in the Maryland case argued that under a 2022 U.S. Supreme Court ruling, Americans have a right to possess arms that are in common use, including the popular AR-15. Yes, they did. And what was actually, the 2022 case was reaffirming the Heller case, which was saying the same thing. But U.S. Circuit Judge Harvey Wilkinson wrote that we declined to wield the Constitution to declare that military-style armaments, which have become primary instruments of mass killing and terrorist attacks in the United States, are beyond the reach of our nation's democratic processes. Maryland Attorney General Bianchi Brown, a Democrat who defended the law, welcomed the ruling. The court's decision today will save lives, he said in a statement. Yeah. The opinion by Wilkinson, an appointee of Republican former President Ronald Reagan, was joined by all of the court's appointees. Really? By Republican former President, well, he must have not been too conservative. Was joined by all of the court's appointees of Democratic presidents and drew a dissent by 5 Republican appointees led by U.S. Circuit Judge Julius Richardson, who called the ban unconstitutional. By the way, U.S. Circuit Judge Julius Richardson is pretty popular. He's actually kind of a favorite if Donald Trump gets a second term. He is a favorite to be appointed to the Supreme Court if that happens. The Second Amendment is not a second-class right. This is what Judge Julius Richardson says. The Second Amendment is not a second-class right subject to the whimsical discretion of federal judges, Richardson wrote. Its mandate is absolute and applied here unequivocal. That's absolutely right. Firearms Policy Coalition and Second Amendment Foundation, 2 gun rights groups that challenge the law, in statements vowed to ask the Supreme Court to take up the case and declare any such bans on assault weapons unconstitutional. Maryland enacted its assault weapons ban in 2013 after a shooter used a semi-automatic rifle in the 2012 mass killing of 20 children and 6 adults at Sandy Hook Elementary School in Newton, Connecticut. While the ban had survived prior court challenges at the 4th Circuit, the court was directed by the U.S. Supreme Court to reconsider the issue after its 6-3 conservative majority changed the landscape of firearms regulation in its landmark 2022 decision. That ruling, New York State Rifle and Pistol Association versus Bruin, established a new test for assessing firearms laws, saying restrictions must be consistent with this nation's historical tradition of firearm regulation. And that's the whole article. So obviously they're in direct defiance of Bruin. They're in direct defiance of Heller. The only thing that's going to change this is it going up to the Supreme Court, which there's a 99.9% chance that this will actually be seen next term. And I think it will be ruled on favorably as long as, our current president and vice president don't try to do anything with the Supreme Court, like pack it or try to get rid of any of our Supreme Court justices like Clarence Thomas or Samuel Alito. But I think we have a good vessel, which is what the Supreme Court wanted, to be able to strike down assault weapons bans all across the country. Because if this does get ruled on favorably by the Supreme Court of the United States, not state Supreme Courts, this will be the new law of the land. And I know a lot of my viewers are from Massachusetts, and we just went through this new assault weapons ban, basically. Massachusetts might rebel and try to say no. What the Supreme Court says is the law of the land. And if you tried to get prosecuted for that, you couldn't, because the Supreme Court would have already ruled on this. Now, I'm not a legal scholar. I'm not a lawyer. What I can say is, if this gets up to the Supreme Court, it will most likely be ruled on favorably. If it does this next term, then we'll see some immediate relief in Massachusetts and states all over the country that are living under these same types of conditions. So if you enjoy these types of videos where we zoom out of Massachusetts and kind of look at the country as a whole, give this video a like, leave a comment or concern down in the comments section. And if you're not subscribed, make sure to do that now. I don't just cover Massachusetts stuff. I try to cover stuff all over the country, although we're taking a primary focus on the Massachusetts gun laws right now. Other than that, guys, thanks for watching and stay unrestricted.